Welcome back. A Tennessee man convicted for the 2007 kidnappings, rapes, and murders of a young couple is seeking an appeal. Eric Boyd was sentenced to spend the rest of his life in prison, but his attorney says he was wrongfully accused.
The way how she was positioned and the way how she was tied to me was telling that she was alive and suffocated in the trash can.
The death of 21-year-old Channon Christian was long and torturous. The medical examiner says Christian was beaten and raped, then trapped inside a trash can. Her boyfriend, 23-year-old Christopher Newsom, was also raped before he was shot 3 times in his head, then lit on fire.
The fire now is superimposed on everything, on all the gunshot wounds, and also if one is alive during fire, then the inhaled soot and all the fumes from the fire are going to be deposited on the airway, and there was none of that.
The couple was heading out on a date on January 6, 2007, when they were carjacked in front of their apartment. 4 people were arrested and charged with their kidnappings, rapes, and murders. A 5th, Eric Boyd, was convicted of carjacking. But in 2018, Boyd was indicted on 36 charges, including murder, after co-defendant George Thomas agreed to testify against him. Prosecutors offered Thomas a reduced sentence from life in prison to 50 years.
When you saw the 3 flashes, who did you see pulling Mr. Newsom?
Mr. Boyd.
And where did he pull Mr. Newsom to?
Directly before me and to the back of the building.
What happened after he pulled Mr. Newsom to that location?
He came back and grabbed the can of gas.
Who did that?
Mr. Boyd.
A jury found 47-year-old Eric Boyd guilty on all counts, and he was given 2 life sentences. Now, Boyd is appealing, saying Thomas's testimony is uncorroborated and that the jury pool was tainted due to media coverage.
It is our position that the evidence is insufficient because Mr. Thomas was a co-defendant, he was an accomplice, and the well-known rule is that you cannot convict a person based solely upon the uncorroborated testimony of a co-defendant or an accomplice.
But prosecutors say the medical evidence and testimony of other witnesses corroborates Thomas's story.
Ms. Mathis's testimony from federal court that she loaned the defendant her white Pontiac the weekend of the offenses corroborated Thomas's testimony, and Xavier Jenkins' testimony that he saw Mathis's Pontiac, which he identified in a photographic lineup, parked behind Ms. Christian's 4Runner at the residence on the night of the offense, also corroborated George Thomas's testimony.
Let's bring in Bernarda and Terry one last time to discuss. Bernarda, the prosecutor who actually graduated from law school with me, laid out why the testimony was corroborated by the co-defendant. Was that persuasive to you?
Yes, it was definitely persuasive. You know that when it comes to putting up a person that is a co-defendant, someone else who played a part in the crime itself, that the court and jurors look down upon this type of testimony. That's why it's so important that there's corroborating factors, corroborating evidence to actually corroborate what this person is saying. And there was more than enough corroborating factors, such as the entire testimony of the medical examiner, as well as the other ladies that also took part in this incident.
Now, Terry, I noticed that the judges had few questions for the prosecutor, and the defense, who said they wanted 5 minutes for rebuttal, actually gave it up at the end. Is that a sign that we should be seeing one side might be winning this appeal over the other?
No question about that, Brian. You never want to give up an opportunity to argue on behalf of your client. I think clearly in this case, the defense was thinking to himself that he had a losing argument. You heard him there talk about it was insufficient evidence because the co-defendant was the only corroborating evidence. And Bernarda mentioned, no, that wasn't the only evidence. And in fact, the judge asked him, even if it had been, that would have been okay. The case law supports that. And in fact, we didn't even hear a response from the defense attorney. At that point, he said to himself, well, okay, Judge, yeah, I guess maybe you're right. So he clearly was either not arguing well on behalf of his client, or he just, didn't do his research, but clearly giving up that rebuttal argument, he gave up and basically, I think, didn't do a great job arguing on behalf of his client.
Now, Bernarda, one issue came up that's interesting. It's very similar to New York, the exhaustion rule when it comes to picking a jury. That seemed to be an issue here because the defense had more preempts to kind of get out some of the jurors. Could that be an issue that hurts the defense here?
think it's an issue that's going to hurt the defense, because in the end, the court is going to determine, based on looking at all the facts and all the evidence that was presented in the case, was it harmless error? Was that an error that could have changed the
Gotcha.
outcome of the case?
All right, thank you both. And thank you for joining us here. We'll see you next time as we discuss justice in America.